Hello, I'm Charles Jamieson. I'm an associate solicitor at Bishop and Sewell's dispute resolution team. We're going to be releasing a short series of videos to assist people with understanding the litigation process. These aren't a substitute for legal advice. And whilst we can provide some guidance as to the formalities, different claims will follow different structures. We will be looking at a general money claim, so following the Part 7 procedure. Claims in different courts, so in the tribunal, or even in the same courts, but just different types of proceedings, say for possession, they may have different procedures. So it's vitally important before you take any steps to understand which court or tribunal and what the procedure is. So this first video, we'll be looking at what is deemed to be the pre-action stage. So this is before proceedings have been commenced. It's expected that parties will attempt to resolve their dispute before rushing off and spending money and using court time seeking formal legal redress. There are different pre-action protocols which may apply, so it's important to check to see whether there are specific steps which need to be taken before commencing proceedings. However, for our purposes, we'll be looking at a general money claim. So as an example, you are owed money by someone. You've provided what you were supposed to provide, but they haven't paid you for it. The first step would be to write to them and say, please pay. We don't want to go to court. But within that letter, you want to ensure that there's enough information there for everyone to understand what the claim is. So you'll be referring to the contract or the agreement, or if it's an oral agreement, what was discussed, including a copy of the invoice, including evidence to show that you have done what you said you were going to do to be entitled for that payment. With the pre-action protocols, the intention is that the parties will resolve the matter from that point to ensure that there is enough information there. Equally, if you're receiving a pre-action letter, be aware of the timelines in which to respond. If you ignore it, it may result in proceedings being commenced against you. As such, it is vitally important to ensure that you engage in that pre-action process before matters escalate any further. I do caveat this. There are going to be some instances, say, where you don't want the other side to be aware that you're looking to go to court, where you're trying to freeze their assets because there's a concern about dissipation. But those instances are not the generality.